have to continue the business of the people of Jamaica on all fronts while we rebuild from the hurricane. So we'll move to the confirmation of the minutes of the meeting held on Thursday, June 20, 2024. All right, we'll start with page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Finally, page 9.
June 20th? June 20th?
Am I looking at the right one?
June 20th, yeah, Mike.
I'm looking at it online. I think that one page rolled over and made an extra page. Right, but we're looking at the same minutes. It's just that the page numbering on mine seemed to be off. I have an extra page with just one line on it, so it's the same minutes. All right, so the bottom, the last line on page 4 of the printed minutes, that begins with eligibility requirements in the regulations and not the legislation. And Ms. Gordon-Jones replied in the affirmative. So that rolled over into an extra page on mine. So, but it's the same, yeah. But it's the same minutes. All right, we'll move to confirmation of the minutes. Moved by Senator Gale. Second? Okay, by Member Morris. Any matters arising from the minutes? There are no matters arising from the minutes. We'll move to matter.
Yes, that's what we're following from. So Ms. Gordon has it.
Go ahead, Ms. Gordon.
Good morning, Chair, members, and colleagues all. In relation to the matters arising from the minutes, Chair, remember there is still the issue of the roles and function of the board and the council. However, it was suggested or recommended by the Attorney General's chambers that we go through the entire provisions and see how the bill comes together before we try to address that issue. So we are taking that recommendation, and we will go through and see how best things play out in terms of the functions and roles of the board and the council, as indicated in the bill currently. The other matter arising from the minutes is in relation to the transitional provisions relating to employment. That is clause 85. The provisions, they were redrafted by the drafter and they were circulated. I'm not sure if the members got a chance to go through. I know member Gale, I'm trying to ensure that I don't say Member Brown. Member Gale had an issue with the clause as they are currently in the bill, and he has indicated since circulation of the redrafted provision, that the draft as updated is accepted by him.
So, Chair, that is in the affirmative. I am okay with the updated redraft as proposed. So I'm fine with this particular item now.
So, Chair, it's for the provision to be confirmed.
Okay, I put the transitional provisions relating to employment to the committee. This is clause 85, 1 through 4. So moved. Members online? Member Miller? I know that the online, yeah, she wasn't.
We're not hearing them.
Member Cuthbert, we're not hearing you. You're on mute. You're on mute, Member Miller. Is that? Yeah. All right, we're speaking to the tech team about it. It looks like you're on mute, so we're asking them to unmute. Okay. Okay, we're seeing what you're writing. If you could just write your confirmation. Okay. We're not hearing you, but we're seeing what you're writing. So if you could confirm the transitional provisions relating to employment. Okay. All right, great. Thank you so much. We should be at the schedules now, right, Ms. Gordon? First schedule.
So we are at page 30 of my document, the first schedule, part A, that speaks to Board of the Jamaica Teaching Council. Paragraph 1 speaks to the constitution of the board. And bear with me, I don't have the document with the track changes. So I'm going to ask the technical team to support me or intervene where track changes needs to be made or highlighted. So it says, paragraph 1, Constitution of the Board. Your committee gave careful consideration to the composition of the board and was concerned to ensure that the body, among other things, had broad representation across the education sector, as well as competence in the technical skills required to give leadership and oversight to the council. Your committee makes the following recommendations regarding the composition of the board, which will create a board consisting of 31 members. It says, maintain the existing provision which requires the Chief Executive Officer of the Child Protection and Family Service Agency to be a member of the board. Your committee does not accept the suggestion to give the Chief Executive Officer the discretion to nominate a representative. Of the 6 registered teachers nominated by an association representing the majority of teachers in Jamaica, 4 of them shall be licensed teachers instead of 5. The number of individuals representing it says a university. I think it should mean a university that is registered in Jamaica should be increased to 4, and 3 of them must be registered and licensed teachers. The president of the University of Technology shall nominate one of these individuals as a representative of that university. It went on to state that subparagraphs F, G, H, and I be deleted and the following provisions be substituted. F, 3 representative of an institution that provides teacher education, which is not a university, 2 of whom shall be registered and licensed teachers. G, 4 nominees of a person who or body that the minister recognizes as representative of religious denominations which own educational institutions in Jamaica, of whom at least 2 nominees shall be registered licensed teachers. And paragraph 1 continued with H, 4 nominees of bodies appearing to the minister to be representative of the interests of parents, of whom shall be a representative of parents who engage in the instruction of children by way of an approved home education program, and 1 of whom shall be a representative of a parent support group for mentally and physically challenged children. And then I, 2 nominees of bodies appearing to the minister to be representatives of the interests of independent schools, not owned by religious denomination, that's a distinction, of whom 1 nominee shall be registered and licensed, a registered and licensed teacher. The number of the board who is appointed because of the number of the board who is appointed because the person is an attorney at law should have a minimum of 7 years experience to be appropriate for appointment.
Notation. There's a notation just to, as member asks for support in relation to the comments that would have been made on the document. So there is a comment that says checks are being done to confirm whether the committee agreed for this to be 10 years, and this is in relation to the years of experience of the attorney being 7, as stated in the report. I know that the attorney on the Professional Practice and Conduct Committee is stated as 10. I think Mr. Foreman can assist me here. The change was made to 10 based on the update of the amount of years an attorney should have in order to be able to sit on the bench. So I'm not sure if Mr. Nash had checked to confirm this, but outside of that, I'm not sure if the committee would want to consider for consistency to have the 10 years for the attorney, as also stated on the PPCC.
What is it on the PPCC now?
10 years.
Oh.
10 years.
Sorry, Chair?
Go ahead, Mr. Foreman.
All right. Hi, good morning, everyone. I was trying to find the hand button. My own recollection, and it's subject to what Mr. Nash found in his scanning of the minutes, was that the attorney on the PPCC should have more years practice because it's expected that person should bring to bear a lot more of the sort of legal training in the conduct of the disciplinary hearings and so on. And I think it was felt that the member on the board itself didn't need as many years under their belt it's expected that their legal training would also be brought to bear. But I think the reasoning was that it wasn't necessary to have as many years under the belt. That's my vague recollection of the discussion that resulted in the attorney on the board needing just a few years less than the attorney on the PPCC. Of course, it's entirely a matter of judgment for the committee. So, whichever party you adopt, I don't think my office will have any objections to it.
Chairman, there's a heavy burden that is going to be placed on that representative on the PPCC. And because of that heavy burden and the required competence and skills, experience is an important qualification. And I support Mr. Foreman's argument in terms of having that person being placed at a higher threshold in terms of experience. The board as a representative does not rise in my mind to that level. And I am supportive of having the board member being, in the very least, a 7-year experience in terms of competence. But the burden of threshold in terms of experience is going to be required for the person who represents on the PPCC.
Agreed. Agreed, member. Do we need confirmation for the 7 years? Committee members?
Well, based on the arguments put forward, I think we are in agreement. So it's just the committee members online? No.
Yeah, committee members online, please register your confirmation of a minimum of 7 years experience to be appropriate for appointment to the board. All right, we're seeing agreement online. Let's move on.
All right, so
Ms. Gordon, sorry, go ahead, Dr. Gordon. Sorry, Ms. Gordon.
Chair, the drafter is asking for us to revisit the nomination of the person for the university. It says the number of individuals representing a university that is registered in Jamaica should be increased to 4, and 3 of them must be registered and licensed teachers. The president of the university shall nominate one of these individuals as a representative of that university. The drafter currently have at least 1 member. So she's seeking clarity as to whether it should be at least 1 or just stating 1.
this is where the president of the university shall nominate one of these individuals as a representative of the university.
Yes.
Madam Chair?
Sir, may I ask? May I? Minister?
Okay. 1 second, Mr. Ms. Sherla on the line.
Thanks, Madam Chair. Just for clarity, what we had before is at least 1 member shall be a representative of the University of the West Indies. And so I need to know should we say at least 1 member or should we say 1 member? Because if it's at least, then it can be...
It makes a distinction.
Right, it can be more than 1.
It can be more than 1.
Right.
So what is it that we are desirous of having? 1 member.
Yeah,
Because if you say at least, you rise it to exposure of having more than 1.
Yeah.
So we have to determine if it's 1 member we want. And if we say at least, we're going to raise now that number outside of 31. The possibility of it? No.
Please put on,
Oh, yes, right, right.
please go on record, Ms. Sherman.
No, I was just clarifying by saying that if we say at least one, then we are giving the University of the West Indies and to the University of Technology the opportunity to nominate more than one of the four. Because we are saying 4 individuals from universities registered in Jamaica. And we are saying at least one from the University of the West Indies and at least one, well, I had put in at least one from the University of Technology based on the report. But the report says one. So I'm just wondering if I should take out at least and just say one.
Just say one.
No, sorry, may I?
Yeah.
Yeah.
Oh, Mr. Foreman, please go ahead.
Right. Yes, so I think in this instance, the report might not be a faithful reflection of what was previously decided. So as Ms. Sherland has pointed out, the revised draft, which was previously presented to the committee, has the language of at least one of the 4 being from UA and at least one of the 4 being from UTEC. And the report is only noting the committee's decision that the UTEC should be included expressly as one institution, but it doesn't accurately reflect the reference to at least one person. So the committee is actually to decide whether it's approving its earlier decision that at least one of the 4 can be nominated from UTEC, which would mean it could be 1, but it could be more than 1, but it's not going to be more than, but I suppose it can be more than 3 because at least 1 would have to be from UA. So that's really the decision, whether you are confirming your decision that there should be at least 1 member of the 4 nominated by UTEC. If you confirm that decision, then the language of the report would need to be adjusted to reflect that.
Clarify something for me, Mr. Foreman, because the at least one can mean 2 things. Giving an option for more than one to be nominated from a university, on the one hand, and on the other hand, the at least one to be nominated is to ensure that at least one comes from a university or one of the universities.
Right.
So which is it that we're seeking to achieve?
Right. Let me respond by reading the provision, the revised provision, which you might not have in front of us. So I'll just read it. 4 individuals, 3 of whom shall be registered and licensed teachers, being representatives of a university that is registered in Jamaica and that provides teacher education, and at least 1 member shall be a representative of the University of the West Indies nominated by the Vice Chancellor of that university, and at least 1 member shall be a representative of the University of Technology nominated by the President of that university. So that's the provision. So the idea is that there will be 4 persons on the board who are representative of universities that provide teacher education. And the effect of referring to UA and UTEC is to ensure that at least one of those 4 persons in relation to each institution to ensure that at least one person from each of these institutions is represented. So of the 4, there will always be
a UTEC and a UE representative.
Right. But it could be more than one UE, it could be more than one UTEC. but it won't be more than 4, at least for this category. So the minister will have a discretion in deciding how to divvy up the quota, so to speak. But that's my understanding of how the provision operates as worked out.
So how do we tidy this up now in terms of what the provision should entail? We now understand what the intention is. But I guess we have to leave it back to the drafter.
Yeah. Well, remember, as I've said, I read what the revised draft was. So if that revised draft is acceptable to the committee, what would happen is that the language in the report will be adjusted to accurately reflect.
Right, to reflect that.
Right. Yeah.
All right, Ms. Shoreline, could you read the revised again, please?
For individuals, 3 of whom shall be registered and licensed teachers, being representatives of a university that is registered in Jamaica and that provides teacher education, and at least 1 member shall be a representative of the University of the West Indies, nominated by the Vice Chancellor of that university, and at least 1 member shall be a representative of the University of Technology, nominated by the President of the university, of that university.
So, Mrs. Shoreline, you are saying take out the at least?
That's what I'm thinking,
Yes.
because then it opens the door to the opportunity to nominate more than one person from each of
Right.
these universities, to the exclusion of other universities. But if that is what, if you want the flexibility, that flexibility, then you would let it remain, and then the minister would use her discretion to know what to do.
I don't really want, I wouldn't want a situation in a provision like that to expose the minister to a discretion that some university may say, why not us? Because you do have other universities. This is specific in indicating explicitly these 2 universities in the first instance. And so having a statement regarding the nomination of 1 from the specifically named university is sufficient enough in my mind. So if we remove the at least, we would not give that raised opportunity for a university so named to be nominated more than 1.
I agree, member. Right, just saying 1 guarantees them a space, and there's no back and forth about.
Right. You just know you must nominate 1 and you nominate the 1.
Chair, in relation to the report itself, I know before the revised draft included the University of Technology, and so the report I am suggesting need to indicate that this was an inclusion, or also indicate the University of the West Indies in the report now.
Right, for the purposes of the report.
For the purpose of the report.
It only spoke to the University of Technology in the
Correct.
report.
Okay.
Madam Chair?
Right, so the
Member Miller?
University of West Indies
One
was
second.
always there.
Please forgive me for not opening the camera because I don't have on a tie and a jacket, so please
All
forgive
right,
me.
no problem. Go ahead, Member Miller. We recognize your voice.
Are we saying that we're going to specify the universities that can nominate someone?
We've already done so. What we're debating now is whether or not we specifically say they have one nominee, which we have agreed. We're trying to, the next question that we're trying to answer is, do we name the University of the West Indies in the report? Because UTEC was named in the report. Right, Ms. Gordon? And we leave room, Member Miller, for other universities.
Madam Chair, I'm in agreement in terms of naming other universities, because there are other universities in Jamaica that has teacher ed department. I would love that opportunity to serve. So I'm in a full agreement in naming other universities, not just the University of the West Indies, not just UTEC, but also there's Northern Caribbean University, and there's other universities as well.
Right, but we've said four individuals can be nominated from a university that is registered in Jamaica. We've given 2 of those slots, one to UTEC and one to UWI, and then the other 2 would be available for other institutions. And to the extent that there are more than 2, I guess when the board comes up for renewal, they could be considered. Right, and that's why we're saying 1 and not at least 1, so that these 2 institutions do not crowd out others. Sorry, Mr.
Thanks,
Foreman,
Madam.
do you still have your hand up? Member Miller, sorry, go ahead.
No, I was saying thanks, Madam Chair.
All right, great. Mr. Foreman?
Yes, thank you, Chair. I just wanted to add that the provision speaks specifically to universities that engage in teacher education. That's the existing amended draft. So that I'm making that point to put the committee in a position to address it tonight. If it's going to limit the UTEC and UA nominee, to be sure that there will always be sufficient other universities to pick from. I suppose Dr. Gordon could assist in indicating what the other potential options there may be. And as well, if you are going to pursue the suggestion just made by Member Miller about specifically naming other institutions, you would also need to know what those other institutions are that provide teacher education specifically. I believe there's perhaps an assumption that you and UTEC will always offer teacher education. Right. But I can't speak for the system at all.
So we're only going to name UWI and UTEC, but we leave room for other universities with teacher education faculties. And that's why there are 4?
Right. Yes, right. So four positions for this category of nomination. So if you...
With 2 of those specifically named, and then 2 are left for other institutions with teaching faculty.
Correct, yeah. That appears with the decision.
Madam Chair, I think Mr. Foreman is asking the question whether we have at least 4 universities which offer teacher training. Because if we don't, then we would leave the at least.
We do.
We have 4.
We do have other institutions that have teacher training faculties.
Universities?
Yes, that have teacher
They are,
training faculties
they are at the
within them.
status of universities. So, Michael, but does the Shorewood, no, they're not universities.
All right, let's agree to just leave open these 2 slots. Yes. No, just name the university, UWI, UTech, and they said the other 2 slots are available for other. Record, please.
Minister, I'm just indicating that it can work with just saying 1 from those 2 universities, and then the other 2 can be taken from the other universities that are providing teacher education, or if it is that there is not 4, then based on your power, you will be able to, because the other 2 are to be nominated by the president of each university.
So the qualification in this case would be that the presidents of the universities are afforded the opportunity to nominate. But for the other 2 areas, it is the minister that can elect or appoint. I just want to be clear in terms of the approach.
All right, may I?
Yes,
Minister?
please.
Just in response to Member Gill's question, how the existing draft would operate is that the Vice Chancellor of UA and the President of UTEC would nominate, each of them would nominate someone.
Right.
And then the Minister would confirm that those 2 persons. Then the other 2 positions, the Minister would decide who should fill those spots.
Okay, so this is
so
where
the minister may decide that Teacher University X has been, doing some good work. So she may communicate with the head of that institution and say, there's a vacancy on the board. I'd like you to nominate someone, and you follow through from there. If you maintain the existing provision that says at least 1 from UA, at least 1 from UTEC, it does create the possibility that the minister could, depending on the circumstances, decide that she wants to have 2 from UTEC, because there's somebody else from UTEC who is doing the kind of work that you maybe want that kind of direct involvement on the board. So that's a distinction. And if if you say only one from UA, only one from UTEC, it means that those other two positions, the minister has to select somebody from non-UA, non-UTEC teacher, university to fill those two positions. So she won't be able to dip back into the UA and UTEC for those two remaining positions.
So, all right. Work with me a little now in terms of the probability. There's room for 4. And we would have specifically indicated that we wanted 1 from UTEC and 1 from UE. So those 2 have the opportunity to nominate from among themselves the 1. Now the question is, the at least being prescribed to those may give them an opportunity to nominate more than 1, which gives the possibility of 4 coming forward.
I thought we were beyond that, though.
No, but I'm listening to what Mr. Foreman would have indicated now. And then the next question is, let's say UE has 1, UTEC nominates their 1. So 2 have to come from somewhere else. But the eligibility is from a university that provides this kind of component. Now, I want to be clear, because the eligibility is from a university, you know. The other university that I am aware of is MICO. Where does that other university representative come from?
Northern Caribbean University.
That provides teacher training?
Yes, sir. That's where I did mine.
Oh, okay.
Yes, sir.
So okay. So that's a declaration. Thank you for that, Member Rob. I just want, you see, whilst we define these provisions and creates a level of eligibility, we want to distinctly be clear that what we are putting in law gives rise to that kind of threshold to be met. All right.
All right, I think we're clear on this now. All right,
Somebody
so
would say pellucidly clear, but clear is clear.
so we will specifically name UWI and UTEC and leave room for 2 other universities that provide teacher education. So move, members.
Aye.
Aye.
Moving right along now. So,
Go ahead, Member Gale.
where was Mr. Nash? No. So, your committee, your committee also deliberated whether ex officio members of the board should have the same voting rights as other members of the board, and agreed that all members should have the same voting rights consistent with the principle in the corporate governance framework for public bodies in Jamaica, that ex officio officers should have the same duties, responsibilities, rights, and privileges as do all appointed board members, including the right to vote. And now I move to paragraph 2, disqualification for appointment. Your committee does not accept the recommendation to disqualify former members of the Senate or House of Representatives from being eligible to serve on the board. Was there a track? I'm sure this one would have had some questions.
Well, what I have in the side notes is that from the AGC, did the committee take a decision, read paragraph 2B, since that provides a restriction, read councillors need clarification on the amendment that the committee is recommending.
All right. Chair?
Go ahead, Mr. Foreman.
Right. I think what we were saying here is, comment was made some time ago. I think this particular issue came up in the context of whether politicians, broadly speaking, former politicians, broadly speaking, should be disqualified from serving on the board. And I think the decision was made specifically in relation to parliamentarians, i.e. senators and MPs. But section 2B also speaks to councillors. So I think we're just wanting the committee just to confirm that the decision is not limited to former parliamentarians alone, but it's also that former parliamentarians and former councillors would not be disqualified from being able to serve on the board. I think that was what the committee had decided, but I suppose just for any avoidance of doubt, we had made that comment to clarify.
So A and B speaks to the existing members of both the Senate and the municipalities. The declaration in this case is persons who no longer serve in those offices and who would have been characterized as being former, but they have gone back to their normal duties in their citizenry. And we were saying that you can't disqualify them because it could have been still a trained teacher who was a counselor. And because you don't want to disqualify persons in the continuation of national service because they had served our parliament or a municipality. We are not to promote that kind of disqualification because that would even prohibit persons from wanting to serve. So I believe what the committee is saying is that you can't disqualify them because they had served. They were a member of parliament, they were a member of the House of Representatives, they are a member of the Senate. Yeah.
I agree, member, but where do we put councillors, former councillors, in that same paragraph? Or it's in another paragraph?
Yes, Chair. I think the paragraph in the report could just be simply amended to...
Yes, to include them.
Indicate.
Include them. Just to be clear, Mr. Foreman.
Right, exactly.
Yes, just for clarity.
Just for clarity.
Not to reverse.
Right, in case someone may believe that, they should be excluded. We just want to make it clear.
All right. So the report should be amended accordingly, and the draft
Right.
bill, yep, should be amended, to include former council.
Yes.
Yes. All right.
So we now move to paragraph 3, temporary appointments. Your committee recommends amending this provision to specify that the appointed member must be absent for 3 consecutive meetings before the minister can make a temporary appointment. I just wanted to look back at what the clause in the proposed bill was indicating. It's just that something jumped at me, whether or not, you know, the absence for consecutive meetings, because you might be absent with reason. Oh, so this is really temporary appointments. Yeah, so it's fine. Paragraph 4, chairman and deputy chairman of the board. Subparagraph 4, subsection 2, your committee recommends the proposal to replace the word appoint with the word elect, and for the minister to appoint the deputy chairman in subparagraph 2. Then I move to,
But, okay, before you go, I'm not
Huh?
quite clear. I'm not quite clear which subparagraph this is referring to. But subparagraph 4.2, when you...
4.2.
But it says,
the members of the board shall appoint a deputy chairman of the board from among the members of the board.
right. So it's that paragraph that we're saying, change the word
So we say
appoint to
appoint.
elect. Change the word, the board shall appoint a deputy chairman to elect.
So I assume the use of the term appointment rests entirely in the hands of the minister. But in this case, the use of the term elect comes from the members to elect from among themselves such an individual.
Okay, all right. This is,
That's my interpretation.
all right, that's clear.
Correct, Minister, Chair, and then to include that the minister is to appoint.
All right, go ahead, Mr. Foreman.
Sorry, could you just repeat what the decision is? I had a comment just seeking clarity on what was decided. My note from the board from the committee deliberations was that the board would elect a chairman and the minister would make the appointment. I think that's what I just heard Mrs. Gordon-Jones say as well. But just to confirm. Yes. Sorry, and then in relation to the deputy chairman, would that be the same process? The board elects and the minister appoints?
Yes. Based on my
Yeah.
notes, that's what
That would be so,
I'm
Mr.
seeing. Yeah.
Foreman.
Yes. So I'm
Okay.
I'm confirming your position, it's similar to mine,
What's in the report?
counsel.
Okay, thank you. Right, so that would mean that the
wording of the report.
this paragraph in the report would be amended accordingly. Some tweaking of the language would be needed. In light of the way the provision was subsequently redrafted. But that can be done later in the background.
I suppose it's
thank
a sequential approach, Mr. Foreman, because you have the board electing first and then the minister would appoint. So you want to make it clear in terms of the sequence of events.
Yes, I believe so. And the last version of the redraft that I have has the minister shall appoint 2 members of the board or council. I think the decision is for it to be the board as chairman and deputy chairman respectively of I think the board. So I think that reflects what my notes says, what Mrs. Gordon-Jones' notes say, and what it appears the committee is comfortable with. So the report will be amended accordingly.
All right, you're in agreement, member. Carry on. Paragraph 5, leave of absence.
All right. Paragraph 5, leave of absence. Your committee does not have any recommendation for the paragraph. Paragraph 6, tenure of office. Your committee does not have any recommendation for the paragraph. And paragraph 7, resignation. Your committee does not have any recommendation for the paragraph. In paragraph 8, revocation of appointment. Your committee recommends an amendment to paragraph 8 to modernize the language and address developments in law. The reference in subparagraph A to quote unquote unsound mind should be deleted, and instead reference should be made to persons suffering from mental disorder as defined in the Mental Health Act. And subparagraph 8F, your committee recommends amending subparagraph F to provide for the revocation of appointment of a member who fails to attend 3 consecutive meetings of the committee without the leave of the chairman, instead of 6 consecutive meetings as provided in the bill. Committee get harsh. Paragraph 10, procedures and meetings. In subparagraph 1, your committee recommends amending this provision to indicate that the board shall meet at least once every 2 months. And subparagraph 2b, your committee recommends changing the time within which the chairman must call a special meeting after receiving a request to do so by a specified number of members of the board. The time period should be changed from 7 days to 3 days. Your committee further recommends that the number of members required to compel the chairman to call a special meeting be increased from 2 to 4. In subparagraph 10, in paragraph 10, continuing, subparagraph 5, in consideration of the recommendation to increase the constitution of the board, your committee recommends an amendment to subparagraph 5 to increase the quorum to 11. On paragraph 11, remuneration. Your committee recommends amending paragraph 11 by deleting the word salaries. In paragraph 12, disclosure of interest. Subparagraph 1, your committee recommends amending subparagraph 1 to remove the words directly or indirectly. Subparagraph 3, your committee recommends amending the subparagraph to provide that notice is to be given in writing. And there was a new subparagraph. Your committee recommends the inclusion of the following as a new subparagraph. Quote, for the avoidance of doubt, a disclosure that is made in person shall be made in writing within 3 to 5 days of the disclosure. Mrs. Sherland, can I ask why the within of 2 specified time frame, within 3 to 5 days? Versus, because you have the maximum of 5 days, but why within 3 to 5? Because you have 5. Is it that the 3 is an encouragement to submit earlier? I don't know, we asked you something, but is there a reason? I just want to know if there's a reason within 3 to 5 days. Or somebody just feels, say, all right, within 3 to 5 days sound good. What happens if you don't submit it within, the 3 days?
No, nothing happens if it's not submitted within 3 days, because you have up to 5 days.
Yes.
But it could be interpreted that you are encouraged to do it as soon as is possible.
So, within 5 days? I'm just asking.
Yes.
If there's any particular reason.
So,
the only thing I come up with in my mind is an encouragement for an earlier period being the 3 days. But let me just ask. Sometimes they tell you that is what is consistent with law, and that is why it's written that way.
I think 3 to 5 days gives an encouragement mentally.
Right. Okay. Service of documents, paragraph 13. Your committee does not propose any change to this clause. Paragraph 14, constitution of committees. Your committee does not propose any change to this clause. And paragraph 15, office of chairman or members, not a public office. And it says your committee does not propose any change to this clause. Filling of vacancies. Your committee recommends the inclusion of a provision that addresses the filling of vacancies. The proposed amendment is as follows, quote, a vacancy in the membership of the council shall be filled in the same manner and subject to the same requirements as apply to an original appointment of a member. As apply? Yeah, but as applicable. Protection of members. Was there any clarification on that? No. Protection of members. Your committee recommends the inclusion of a new paragraph protecting members of the board from being liable to have any action, suit, prosecution, or other proceedings being made personally against them for work done bona fide in execution of their duties. And that where any member is exempt, the council will be the proper subject of the legal action. Anything on that? Nope. So we move to the second schedule, teacher support services. Your committee recommends the following amendments to the second schedule. In the heading, to change the word teacher to teaching. Next one is to include in the heading words to indicate the specific type of personnel to which the schedule is concerned, to include nurses, counselors, coaches, and laboratory technicians. Is that the complete listing? And then you have the expansion of the list to include coaching services and social services.
Could there be an other, just in case we don't have an exhaustive list of services?
If you don't think of the others, don't include it now, Minister. You see, when maybe if you use the term other, then you will see some others germinating. All right. So, third schedule, the Jamaica Teaching Council, seal and execution of documents. Paragraph 1, your committee does not have any recommendation for this schedule. And we move to the fourth schedule, fitness to teach, further provisions. Subparagraph 1, subsection 1A. Your committee, in its discussions, noted that the word, quote, they, might give the impression that a criminal record check was done in every instance. Your committee proposes that the subparagraph should be amended to read, quote, any criminal record check, end of quote, or words to the effect of, quote, where applicable, any criminal record check. Is it that we're supposed to choose one or the other?
Mr. Foreman had some side notes. Mr. Foreman, would you come in here? Fourth schedule.
Mr. Foreman?
Thank you, Minister. I'm reviewing the language to figure out why I said what I said. May I have a moment, please?
Sure. All right, so, member, while Mr. Foreman contemplates, you want to go on?
Do I proceed?
Okay. Well, you
No,
could
sorry.
go-
May I
Are you ready, Mr. Foreman?
yes. So I think at the time I felt that the proposed change was not that significant, but I can see why the committee decided the way it did. It's not a comment that needs to be addressed. It doesn't go to the substance of the provision.
All right. Carry on, member.
All right, so paragraph 1. Your committee noted the comment of one stakeholder that the paragraph potentially conflicted with sections 24.3 and 25.4 of the Disabilities Act. Your committee recommends an amendment to the provision to include a proviso to subparagraph 1E, words to the effect of, quote, provided any action did not violate the Disabilities Act. Eh? Potato, potato.
Carry on, member.
You learn something every day.
Oh, there's a side note. Hold on. Mr. Foreman, you also have a side note here.
Yes, I did. I looked at the provision of the Disabilities Act that was referenced by the stakeholder. That particular provision requires equal treatment for persons with disabilities, and it prohibits discrimination by reason of their disability. The paragraph that was the subject of the comment requires the council to accept the report of a medical practitioner whether that person has any physical or mental incapacity or illness that will or is likely to interfere with the practice of teaching. So the paragraph itself doesn't give the council power to do anything. All it says is that the council is required to accept the medical report of the medical profession. So I didn't see where the recommended amendment was appropriate in the context of that provision. So it's essentially this schedule only lists the factors that are to be considered by the council, but the schedule itself doesn't empower the council to make a decision. Okay. Those decisions are in the substantive areas of the legislation, where the council is empowered to decide on an application for a license or an authorization.
Ms. Gordon.
And
so you're saying that 1E is okay as it is?
Yes, that's my submission to you. Yeah. And I would add that as a public authority, the council will be required to act in a manner that's consistent with, or put it in a negative, not inconsistent with other applicable legislation, such as the Disabilities Act. So that when it's taking a decision on whether to grant a license or an authorization, the council would have to take into consideration that it can't deny anyone solely on a basis, deny someone on a basis that is not prohibited, that is prohibited by law.
Right. Understood. So we move to subparagraph 1C. Your committee noted the recommendation.
Hold on.
Sorry. No, sorry. You can't move as yet. You need to decide if you are accepting the proposal to the provision as is.
Well, sorry. I was
Mr.
running
Foreman,
ahead of myself. But
Mr. Foreman, are you saying we just revert to what is
in 1C?
Yeah.
1E, sorry. That's why I asked the question.
Yes, so I'm suggesting that the original, what's in the bill at the moment, is adequate.
Is adequate.
Yes.
All right. Okay.
So I was just running ahead of myself in asking the question and getting the answer.
Okay. All right. Go ahead, member.
Yeah. 1C, your committee noted the recommendation for issues of biological, non-biological determinants to be specific and for clarification of the term his in relation to members of the teaching profession. Your committee accepts the concern raised and recommends the use of gender-neutral language in the provision. Sometime in the future, we're going to start seeing some other kinds of languages. So we move now to the 5th schedule, Appeals Tribunal. And paragraph 1, your committee makes the following recommendations for amendments to the composition of the tribunal to expand its representation and skill set. The first one is number of members should be increased from 3 to 5 by including as categories for appointment an attorney at law and a person representing the interest of parents. In addition to a retired judge of a superior court of record, the chairman can also be an attorney at law of at least 15 years experience. Yes, but when it says the chairman can also be an attorney at law. Oh, okay. So we're making the qualified distinction in what can create eligibility for the chairman. Either or. Okay. So we move to paragraph 2, appointment and tenure of office of members. Your committee considered the scenario in which tribunal chairman, which the tribunal, insert the tribunal chairman is absent for a particular sitting, and whether the panel would be able to continue in those circumstances. Your committee noted that provision was made in the 3rd schedule to the Fisheries Act 2018 for this eventuality. Your committee recommends an amendment to the provision to permit one of the other members of the tribunal present for the sitting at which the chairman is present. It should be absent to act as chairman for the sitting, the choice of chairman being determined by the members present at the sitting. All right, so we have 5 members of the tribunal. The chairman is absent, and so leaves you with 4. And what this is saying is that you should now choose among yourself for the sitting to take place to identify among the 4 a chairman. What's the skill set for the composition again?
Ms. Gordon, the skill set of the tribunal.
Retired judge, retired teacher, representative of Professional Teaching Association recognized by the minister and nominated in a manner approved by the minister. And we would have added the parent representative. So the retired judge or attorney becomes absent for whatever, no.
So,
Yeah.
So you have the chairman,
Yes.
and the chairman can be either a retired judge or an attorney at
Or
law
an
with
attorney.
15 years.
Yes.
So there's another attorney at
There's
law
another
but
attorney.
with 10 years.
Ah, got you. Okay. So that it is the possibility that in the absence of the chairman, that the nominee can come from that attorney. I must tell you though, personally for me, I don't really support the idea of a panel hearing a matter and there is a substantive member who would have been hearing the matter being absent, and there's a call for a continuation of hearing the matter under those circumstances. My preference is to have a postponement until that substantive member is available. This is not a board meeting. This is not a regular meeting. This is an instrument entrenched in law for a particular purpose of which the objectives are very clear. And the decisions are likely resting on each member being presented with both verbal and physical evidence. This is, and I, the reference was made in terms of a provision in the Fisheries Act of 2018. I don't know what the context was for applying that provision in that particular legislation. I don't know the context to which it would have worked, or is it working? Has it been tested?
Member, I think Mr. Foreman wants to make an intervention. Mr.
Okay.
Foreman?
Thank you, Chair. No, I'd not to so much make an intervention, but I just found the provision from the Fisheries Act, which I shared in the chat. So the provision says, in the case of the absence or inability of the chairman to act at any sitting, members of the tribunal present at such meeting shall elect one of their number to act as chairman at that sitting. So I just provided that for information purposes. I take all of what Member Gill has said. I'd only point out that I assume that there's an assumption that the members will not exercise this option in circumstances where, for example, there's evidence being taken and that sort of thing.
Mr.
Sorry. I'm not disagreeing with anything being thought.
Yes.
I'm just saying that a sitting includes not just the taking of the evidence and the deliberations and so on. It could just be the delivery of the decision is a sitting of a tribunal, or there could be some other decision. So I assume that the provision is there to contemplate those types of situations. Now, if the committee decides that that is not sufficient reason to have this possibility there, then your decision would be not to include that provision, so that the tribunal will always have to be fully constituted in order to sit. So I'm just adding that to the discussion. It's a decision for the committee to make.
Well, you see, the intention of the objective of the Fisheries Act might not be the same kind of purpose as being outlined in this piece of legislation. The Fisheries Act might be an application for a renewal of a license, non-renewal. It's a different framework. this particular tribunal, I would not want, if I am making a submission on behalf of an individual, and this is my closing submission, having presented all the evidence, for the chairman to be absent and not to hear my closing submission, which is in effect may make the determination of a judgment and expose individuals to the possibility of a change in direction. Remember now, we would have expressively stated the skill set of this particular chairman, being that of a judge or an attorney with X number of experience. So the eyes in the lens of that person is to a particular extreme. I don't feel comfortable, Chair, in supporting this move of a continuity of a hearing as expressed here. My preference was to have a postponement. In fact, if I was the representative, I would strongly object. This has too many ramifications in my mind.
In terms of that member, unless that chairman will no longer form a part of the tribunal hearing going forward.
Going forward. I would have seen situations where, because a chairman was incapacitated and could not perform, hearings have to start all over again. So, I really don't support this approach, Chair.
So first, I'm going to ask for a correction to what's there in terms of the second to last sentence where it says that with the chairman is present, that should be absent, right? That word should be absent, just for the record. But also on reconsideration of this and the gravity, as a member said, of what's being considered and the decisions, it can be life-changing or at least profession-changing, that we probably do not want to only have 4 persons hearing, right, rather than the 5, and for the chairman to be different. So I'm with Member Gale on this, that we should try to preserve the 5 members at all times, and if one is absent, then we seek to reschedule, even though that comes with its own set of risks as well. Committee members, on reflecting on this, any new thoughts?
Member Green is still there, being an advocate.
Member Green, can we hear from you, given that we looked to the 3rd schedule of the Fisheries Act on this?
Some minutes though. Sorry, I missed some of the discussion. Unfortunately, I in transit, so I had dropped off. So I would have to be brought back up to
Sure, not a
as to
problem, not a problem, Member Green. We are considering the scenario in which the tribunal, the chairman of the tribunal is absent for a particular sitting. If you will recall that this would be a 5-member tribunal with very specific skill set among the members, especially the chair. And for that chairperson to be absent, the committee had recommended an amendment to permit one of the other members of the tribunal present for the sitting, with the chairman is absent, to act as chairman for that sitting. Member Gale, on reconsideration, is quite against this, considering the carefulness with which we would have had to have chosen the tribunal members and the skill set we're requiring, and just the gravity of the decisions that would come from this tribunal. We had looked to the 3rd schedule of the Fisheries Act 2018 as an example of this. But I believe we're saying that the gravity of the situation here with this tribunal for the teaching council is of a higher order, just greater weight, with decisions that can impact persons' profession, their career path as well.
So I think in all of these things, Minister, colleague, we have to kind of consider the other side as well. In other words, if for whatever reason the chair were to fall ill and not be able to chair, the question is, would we want the committee, the council, to be so neutral that it could not go ahead? Yes, the chair is specifically chosen, but everybody who sits on the council is there, having been placed there, and having been placed there, I am very sure that in the absence of the chair for a meeting, that it would, in my mind, it would be better, a better governance structure for a chair to be a temporary chair to be placed there, as we have said, and for the meeting, the deliberation to proceed. I wouldn't want that because the chair can't make a particular meeting. I wouldn't want that the meetings can only be had if the chair is available. I don't think, that may have unintended consequences. So I think as we have deliberated before and have looked to other entities to so structure it, I would support that structure where somebody can be appointed in the absence of the chair.
So, Member Green, this is the question now of the continuity of the deliberations, where you have a 5-member established panel. What this is suggesting at a particular juncture is the absence of the chairman for the other members to elect among themselves a chairman, which in effect is the pursuance now of 4 members hearing the matter on that particular occasion.
I get you.
Yeah. And my preference, if based on what you had indicated, where the chairman may have been absent due to illness for an extended period, we have to find a chairman. But the composition of the tribunal is also essential in terms of having that 5-member tribunal, that 5-member panel to hear the matter. And that's an important component of this.
Again, I think I see what you're trying to guard against member Gale. But, you know, again, the tribunal having been put in place, and, you know, it would now be 4 members at that point. The question is, would you want to, and even with the person who comes before the tribunal, want to have their matter further delayed because the chair is, and my understanding is that this will be that the chair is unavailable, right? So it's not that you're looking to choose a new chair, but that the chair cannot, for whatever reason, and maybe I should ask for the actual provision to be read, just to refresh myself. But at that juncture, the other option would be not having the matter proceed and having a different date to be set. And I'm not sure that would be in the best interest of anybody, including the tribunal or the party who is appearing.
Then if a representative is not available, defending the person, another date now be set?
Chair.
That's on the person's side.
Chair, just an observation. The appeal tribunal under this bill, it does not have a quorum, and so
under
it
which
is
bill? Under which bill?
The Jamaica Teaching Council bill. It does not have a reference to a quorum, so that means all 5 members are expected to sit, whilst in the Fisheries Act, it speaks to at least 3 members. I was looking at the bill because it's not coming up on my computer, but okay, it's up now. Let me just read for the committee the provision under the 3rd schedule, which would have informed that provision in relation to the absence of the chairman. Just crave your indulgence. So the 3rd schedule says, Constitution of Appeals Tribunal. The Appeals Tribunal shall consist of members appointed by the minister as follows: 2 attorneys at law who have practiced for at least 10 years, and B, 4 other members who shall have wide knowledge of the experience in the fishing and other matters relating to fisheries. Subparagraph 2 says, if there are fewer than 3 members, but at least 2 members in office, the appeals tribunal shall be deemed to be properly constituted for a period not exceeding 90 days after deficiency in the number of members first occurs. So this has 6 persons for the Constitution, and it says at paragraph 4, in terms of the hearing of the panel, it said a matter referred to the appeals tribunal shall be heard and determined by a panel consisting of 3 members of the tribunal, one of whom shall be an attorney at law as assigned by the chairman of the appeals tribunal. So here it speaks to the hearing panel. In this bill, it does not have that, so it means that all should sit. And so...
In this one?
Correct.
But that one speaks to a quorum.
Correct.
And so if it speaks to a quorum, then it is once you reach that quorum, you can proceed.
Right. So that's the difference.
For this tribunal, we had not said there should be a
No, we
quorum,
never
because
defined a
but
quorum.
we want all 5 members to sit, is what I remember of the discussion that we had. So then to have this in paragraph 1 seems contrary to that.
Could we go over paragraph 1 again? Let me just hear it.
Sorry, member, repeat.
Could you just read paragraph 1 again, Minister, or have the team? Sorry.
For which one, in the JTC bill?
Yes.
Paragraph 2, sorry. Appointment and tenure of office of members. Go ahead, Member Gale.
That's the
Paragraph 2.
paragraph. In the case of the absence or inability to act of any member of the tribunal, oh, in the report. No, man. I was reading
Member
from
Green,
the
the
bill.
report or the bill? Which one do you want to be reread?
You know what Bill says?
Okay,
So the bill says, and this is 5.1, in the case of the absence or inability to act of the chairman of the tribunal, the minister may appoint any person to act temporarily as chairman of the tribunal. And then 2 now says, in the case of the absence or inability to act of any member of the tribunal other than the chairman of the tribunal, the minister may appoint any person to act temporarily in the place of such member. Even that, is contrary now to what the report is saying, because the report would have led to a different interpretation, which is not contained, Member Green, into what the act is saying. So we were reading from the report in the first instance. And so this is what the report said, which would have raised my concern. Your committee considered the scenario in which tribunal chairman is absent for a particular sitting, singular, and whether the panel would be able to continue in those circumstances. Your committee noted the provision was made in the 3rd schedule of the Fisheries Act 2018 for this eventuality. Your committee recommends an amendment to the provision to permit one of the other member of the tribunal present for the sitting at which the chairman is, and it should be absent, the word absent used instead of the word present, to act as chairman for that sitting, the choice of chairman being determined by the members present at that sitting. Now, I would have raised concern because we don't know at what juncture of a hearing that the chairman would be absent. It may be when strong material evidence to which that chairman would have been relying on would have been presented, or it may be a situation where a representative is making closing submissions, which you know is very critical in the outcome of a judgment. It may be situations where submissions of other cases material to this matter are being presented in the absence of this chairman. Is it a situation where we want to make a declaration for the continuation of a hearing in this absence? And remember, we're speaking about the question of for a particular sitting, not an extended period to which a chairman might be out. We're speaking about a particular sitting. And in my mind, a particular sitting can be postponed. given the gravity of the situation. So that was the context, Member Green, to which I had raised the concern. But even what is contained in the proposed legislation, in particular to this clause, I can't recall why we had gone to this extent. But it is contrary in my mind in terms of what is in the proposed legislation to which the report is now suggesting. That we would have deliberated and concluded.
Yes, I think looking at all the provisions and the report, it kind of seems to me that one, the provisions speak to where a chairman becomes unavailable in a sort of temporary manner, and that the minister would appoint somebody to act in that regard, and one where a member of the council, tribunal becomes unavailable, and somebody being appointed in a temporary circumstance. Clearly that there, it's not mind to, if you're having a sitting and the chairman is unavailable for that sitting, whether that sitting goes ahead and who chairs the sitting. So I guess the contemplation was a more, as you have just said, that sort of singular, there's a sitting to be had, the chairman has indicated that he or she is unable to make this sitting, whether the sitting would proceed or whether the sitting would have to be put off because the chairman is unable to make it. So I guess it is really for us to determine if the chairman has to be present for all the sittings to go ahead. If the council has to be, or tribunal has to be advised for all the matters to proceed. As you realize, the scheme is a little different from the scheme in the Fisheries Act, because the Fisheries Act chooses from among those who constitute to hear the appeals. So it has as was said, it has sort of a quorum. So this one, Minister, I'm not sure. It really comes down to if we believe that there must be 5 persons for the matter to proceed, and if that has to include a chairman that is appointed by the minister, whether the original chairman or somebody temporarily. And but again, on the flip side, it's just the challenge with these provisions is if you have to have 5 people and persons end up not being able to make it, what happens to the matter? And does that delay these proceedings to a level that would be considered unreasonable?
But 5-2, Member Green, satisfies that in the case of the absence or inability to act of any member of the tribunal, other than the chairman of the tribunal, the minister may appoint someone. And 5-1 speaks of in the case of the absence or inability to act of the chairman. So it assumes in my mind that if there is going to be an extended period to which the chairman or a member might be absent, then it gives rise in a provision by the minister to act. But when you now moves the level to a singular sitting to which they are going to, for the continuation, sometimes, a tribunal must be given the discretion to determine some rules of how it operates in terms of standard procedures. And this is one of those cases where, in the absence of a member or the chairman, the tribunal can determine, exercising its discretion, to postpone. Yeah?
I'm with you on the last point. I'm with you on the last point in terms of the tribunal determine its rules of procedure.
Yes.
And the law having the overarching framework, I believe what the law speaks to is a sort of, not a singular sitting absence, is the sort of inability to act or a significant absence that would require the minister to be called upon or the minister to intervene to appoint somebody. So I agree. If you're saying that ultimately we don't have to treat with what would happen in a particular sitting in the law, and that is something that would come as a part of the rules, then I have no difficulty.
Right. Just like in the standing orders of Parliament, if the leader of government business is not here, someone assumes. That's by standing order. Huh? But I wouldn't want to place such an operative instruct in law. I don't think there is any need to place that operative instruct in law. So I'm fine with whatever was here in the proposed bill and allow the tribunal in any case of this nature to exercise its discretion.
I have no difficulty. Chair, I have no difficulty with that approach.
Chair, I'm just noting in terms of the temporary appointments for the other provisions in the bill in relation to the board members and the PPCC, which you would see in a further reading that it said that they should mirror the provisions of the board. We're not seeing here how often, how many times the person should be absent before the consideration is had to appoint someone in the space. So it's not indicated.
So in that case, it would be consecutive absence.
Right.
But work with me in this case now, because you absent once. A date is set for tomorrow morning. Mm-hmm. Tomorrow being the 19th of July. Right. And the chairman is absent for whatever reason. Let's assume that they had agreed for some dates, and the chairman now becomes unavailable. Then this is when the minister knows. So what you're suggesting is to define the extent to which that unavailability may arise.
Correct.
And you're saying that it also ought to be consistent with the others.
That's the proposal.
What's the others?
Currently, for the board, it says 3 consecutive meetings.
Mm.
Sorry, is there a deliberation that we're not hearing? Not sure.
Yeah, the technical persons are deliberating, but they're not on.
Okay.
They're not on on the record just now.
Chair? Good afternoon,
Go
Chair
ahead,
Nadine
Ms.
Wilkins
Wilkins.
here. Just a question.
Yes.
When it refers to 3 consecutive meetings of the committee, was that an error? Should it have been board? I know the original provision said board or any of its committees. I'm just wondering whether committee in the second line is an error.
So Ms. Wilkins, could you direct us to where you're reading?
Your committee recommends amending, am I at the wrong paragraph? F, to provide for the revocation of appointment of a member who fails to attend 3 consecutive meetings of the committee without the leave of the chairman.
Where is that? Are you reading the bill or the report?
Both. Well, I have both in front of me. I was reading the report a while ago.
All right, what page of the report?
32.
We're at 36.
Well, I hear that there's a revised one, and I don't have the revised one. So I'm not sure if where on the pagination why it is the same.
All right, Mr. Nash is going to send you the most current report now.
Yeah,
We're
because
on the-
36
we're
for
on
me
the
doesn't
fifth.
have that.
We're on the 5th schedule.
Yes. But I don't, okay. That's the schedule, but I don't have the amendment. Thank you.
You're welcome.
As soon as I get that, then I'll be on the same page.
All
Thank
right,
you.
no problem. But those online or technical persons are still deliberating off the record.
Chair, we are asking if the chambers can indicate to us whether that proposal is workable, because what we're looking at is the bill currently requires all 5 members to sit, and so if it is that a member is absent, as Member Gale indicated, then they would have to postpone that meeting in order to ensure that all persons are present. But what if it's a case where, say for example, someone falls ill and they are in a hospital for an extended period, then it would mean that someone new would need to be appointed. And so in order for the best interest of the party involved in the matter, then you would need to have a new appointment in order to have the matter heard.
So
Isn't that what it
5-1,
says in 5-1?
5-1
5-2?
deals with that.
Yeah,
5-2
1 and 5-2.
deals with that.
Yeah.
What I think your concern would be is
The
a
time.
duration.
Right.
A duration.
Would it be 3 or less than 3? Mr. Foreman, is it possible for you to comment on this? Seeking your assistance.
Remember now, this is not, a board or a committee might have scheduled meetings, set dates, span over a period of time. This might not be that kind of situation. We might set a date today, and we don't know when the next date will said, it's the parties who determine. You know, this kind of scenario allows for some level of flexibility in the continuation of a sitting. I don't know, Chair. And I understand that if the person is out sick for a defined period, it triggers the action in terms of 5.1 and 5.2. Yeah? It's just for us to define what that period ought to be. I particularly don't like the idea, is it 3? Why not 5? How about 7? How you declare that? How you determine that? Because I've seen in this committee, you know, that we just pick a time because a time sounds reasonable without taking the consideration of the parties involved. The primary objective is to ensure the expediency of deliberations. That's the primary objective. Yeah? But what would be reasonable? Again, we may look at how other tribunals operate. The one that I'm accustomed to exercises its own discretion. In this case, it exercises its own discretion. Where the tribunal itself decides that, okay, if we have to appoint a chairman because chairman is incapacitated for a defined period, I might ask, what is the practice if such a situation would have found itself? I've known chairman to be out, and what the tribunal would have done is to reorganize. But then that particular tribunal has divisions. It's more expanded in nature than this one. Yes, but what the technical team is suggesting is, what is that qualified period of absence? It don't say it in here. It does not say it in the proposed bill. But the situation might present itself.
Thanks, Madam Chair. On another point having to do with paragraph 5, temporary appointments, I don't think the report captures some words that we perhaps need to add to 5.1 to indicate that the appointment made by the minister shall be made in the same manner and from the same category of persons, if any, as the appointment of the chairman. So in the case of the absence or inability to act of the chairman of the tribunal, the minister may appoint any person to act temporarily as chairman of the tribunal, and such appointment shall be made in the same manner and from the same category of persons, if any, as the appointment of the chairman.
I would go along with that. Member Gale. Same category of persons.
Read that again, please.
Currently says, in the case of the absence or inability to act of the chairman of the tribunal, the minister may appoint any person to act temporarily as chairman of the tribunal. And these words that follow occur elsewhere, and such appointment shall be made in the same manner and from the same category of persons, if any, as the appointment of the chairman. Meaning, in the case where a judge is selected or an attorney at law with 15 years
Right.
experience.
You're safeguarding the consistency in terms of those that you're selecting from. No difficulty with that. That's an important safeguard. That you don't go out and you choose, well, let me not say, anything outside of what we would have qualified. So that's fine. And the same would go for 5-2.
All right, so committee members, I believe we could confirm that amendment to schedule, the fifth schedule, paragraph 5.1 and 5.2, to add the safeguard in the event the minister is appointing someone to act temporarily as chairman or appointing any person to act temporarily in the place of such a member.
Leave it as that. No. Leave it where, with that proposal.
As read by Ms. Sherland.
5.1 and 5.2.
5.2.
With
Yes.
what was just proposed in terms of the
Choosing the
how
same.
we choose in
choose
the
same
absence.
skill set.
Right. I can't give you a day. I don't know none. Not within 3 to 5 days.
All right, members, so approved 5.1 and 5.2 with that amendment, the safeguarding amendment.
So I can move now to the 6th schedule.
Yes.
Oh, sorry.
What? What?
Can't give you a date.
We're not able to hear you. Please go on record.
Chair, I was just querying whether a time frame in terms of absence will be inserted or we are just going to leave the provision as it is with the proposed amendment that Ms. Sherland just read in terms of the safeguarding.
Chairman, this member cannot identify a date. I don't know how we're going to. So why 3? Why 5? Why 7? I don't know. I am going on the premise that allow in the absence, if the tribunal says to the minister, Minister, we're having a challenge. This is the situation. Then the minister can exercise the discretion and appoint. But I feel uncomfortable if I was that chairman, and for whatever the reasons are, I might be out for 3 days and I no longer have on the fourth day, I'm good. But my role as chairman gone? No, man. Exercise some discretion where that is concerned. The minister can have a conversation with the chairman and make a determination. Suppose a member of that tribunal want to be chairman. I leave that to a minister to make a determination. This is one of the areas that I would promote and suggest and strongly encourage a flexibility in approach.
Only if that member meets the eligibility criteria.
Of course. We 5.1 and 2 with the expanded update.
We already agreed
Makes that
on
qualification.
We already agreed on that, yeah. Right. So I agree, member, the minister should be able, the chairman should be able to speak with the minister to say what the situation is.
Yes.
The chairman can determine.
Yes.
If
This is
he's
one
going
of
to
those
be
situations
absent,
where a chairman
yeah,
can
to
make
say,
a
I'm going to be out for
yes, and the
3
minister
months.
can decide.
Or another member.
Or another member.
Or another member.
Yeah.
Yes, or another member.
Yeah.
Someone can be elevated, But we should ensure and
Conversation.
promote that level of flexibility.
All right.
So,
Ms. Sherland, you wanted to add something?
Yes, Madam Chair, just to ask the members to consider paragraph 1, where it says that subject to paragraph 3, the appeal tribunal shall consist of 3 members, 5 members, that is to say, and
subject to paragraph 3, the appeal tribunal shall, so this is 1.
Sorry, there's a typo.
This is in the bill now.
In the bill.
In the
Draft bill, right there where Ms. Sherland is reading. It says it should be, huh?
Increase from 3 to 5.
Right, but I'm just
5,
saying, look
5,
at the
we now
word.
have
Look at
5
the word.
members.
So
that's
it
there.
says in the bill 3. So that is, it should said 5. It
5.
should have said 5.
yes. And the amended version would say 5 because we have increased the membership from 3 to 5.
And then you should have A, B, C, D, and E.
Right. And D says, well, will say, a nominee of a body appearing to the minister to be representative of the interests of parents.
parents.
We said that.
Yes.
And so there was a discussion which raised the question as to whether we should now include an additional provision to say where a member of the tribunal is not nominated for appointment within a reasonable time, the minister may nominate and appoint a person from the same category of persons to the tribunal. That was not included in the report, and I can't fully remember where the discussion came up, but it may be pertinent to the new D, which is saying that the minister will appoint somebody who is nominated from the, to represent the interests of parents.
Parents.
So where that nomination is not made, and we could say within a reasonable time, the minister may nominate and appoint a person within that category of persons to the tribunal. So the question is, should we include that new provision to take care of that when the nomination is not made in a reasonable time?
Okay, let's put that to the committee as we look to close. All right. All right, carry on, member.
Oh. Yeah. I was just trying to look back at what the report says in terms of the constitution of the tribunal. So yes, we should put that in there. So I can move now to the 6th schedule. Amendments.
Yes, member.
Amendments to other enactments. Your committee does not have any recommendation for this section. And the memorandum of objects and reasons, your committee does not have any recommendations to this section.
Member, I think we have for Part B, we will pick that up at the next meeting.
At the next meeting.
Yes.
Whoa.
And that would be the final.
All right.
Yeah.
Having exhausted today.
Yep. All right. Any final comments from our technical persons? No, online. Mr. Foreman, any members? Otherwise, we will bring this sitting to a close and we'll pick up in the next sitting on Part B, which would be a new insertion, Professional Practice and Conduct Committee. All right, that will be published. The next date will be published. More than likely be in. We'll send it out via email. No, you don't. No, I don't know. What does the schedule look like? All right, we'll look at the dates and we'll advise. All right. Members will be so advised.
Chair, just a
yes,
question.
Ms. Wilkins.
I have another meeting and join later, you may have. Have you already looked at the transitional provisions in relation to employment? Was
Yes,
that
we did.
taken already?
Yes, that was the first thing we took
I see.
at this
dear.
sitting.
All right.
Yep.
Thank you.
Yep. All right. Thank you so much, members. Mr. Nash, I think we'd skipped over the apologies, so let me say it for the record. There's an apology from Senator Dr. Dana Morris Dixon, from Dr. Angela Brown Burke, and from Honorable Robert Nestor Morgan. Any other business? Again, for the date of the next meeting, we will advise you with plenty of time. So we move to the adjournment to say thank you, as always, for your continued diligence on this matter. Looks like we're getting to the end. Thank you. Yep. Motion for adjournment? Moved by Member Gale.
Aye.
Thank you, Member Miller.